There's a lot of cops there for nothing. They put these women in the back of these cars. They get their IDs from their car, from the Loggervale car, and then run their IDs. Both the daughters are calling 911 saying, we're being detained by these police officers and we haven't done anything. Please send help. And finally, the police take their phones from them so that they can't try and get help any longer. And these officers had dug themselves into a hole and couldn't figure out how to gracefully get themselves out of it. Of course, it was saying, I was wrong. I'm sorry. Is there anything we can do to make up for this and show them on their way? But they didn't do that until the sergeant came. And eventually it's a sergeant who shows up, who is the one that speaks with each of the women and releases them. Brian, you remember numbers well. What was the verdict?
Well, the verdict, that's a round number. It was $2.75 million for each of the plaintiffs, 3 plaintiffs, total of $8,250,000.
This would have still been a substantial verdict, but I think it would not have been nearly as large as it was if the defense had simply got up and said, you know what? In retrospect, we were wrong. That's not what the cops were thinking at the time, but in retrospect, we were wrong. We're really sorry what they went through. That's not what we're about. And you should compensate them each, $100,000 or $150,000 or something. I think that would have had a dramatic effect on the case, but instead they went the other direction and tried to attack.
Howdy, and welcome to the show. I'm really excited about today's program. We're doing something a little bit different. What we're going to be doing today is one of the first of what we're going to call our after-action reviews. And in that, we're going to be taking a look at a verdict or other result, have the people involved, and kind of parse through how they got what they got. In this situation, we're going to be talking about the Loggervale case, which was a notable civil rights case. We're going to be speaking with Joseph May, Brian Gearinger, and Craig Peters, the lawyers who were involved in this outstanding verdict. They were also able to preserve when it went all the way through appeal. So without further ado, I'm going to turn it over to Craig, who I believe is going to help give a little bit of a backstory to the incident that gave rise to the case itself.
Thanks, Miles. Yeah, so this case started off with a mom and her 2 daughters traveling from their home in Las Vegas, going to Berkeley, where the oldest daughter was going to take a test. She was in college. And after the test was over, the 3 of them plus a cousin were going to travel to San Diego to celebrate the youngest daughter's 18th birthday. And the plan was to drive during the evening. The daughters could sleep in the car while mom drove. And then when they got to Berkeley, oldest daughter would hopefully wake up refreshed, ready to take her test, and off they go. They stopped along the way in Castro Valley. They were a little bit ahead of time, and they stopped in Castro Valley so that the 2 daughters could get coffee and kind of wake up and refresh, use the restroom. And they pulled into a strip mall in Castro Valley where there was a Starbucks. And mom's told the daughters, go ahead and go inside and do whatever you need to do. I'm going to catch a few winks here since she'd been driving all night. She put her seat back and closed her eyes. The daughters didn't really wake up, so they sort of were still in their seats as well, not moving. And preceding this day, the police department had become aware of some morning burglaries that had happened at this particular strip mall where these burglars were doing these kind of smash and grabs. So people would call in their Starbucks order, they'd pull into the strip mall park. It was kind of a circuitous route you had to take to get to the Starbucks. So they would take that route, go inside, get their coffee, come back out. But in the meantime, somebody can steal some stuff out of their car. So they were all on high alert. They were watching this particular strip mall. And on this particular morning, these 2 officers, a male officer and a female officer, approached the car. Male officer's on the driver's side, female officer on the passenger side. And he knocks on the window, clearly startling the mom and the 2 daughters. Youngest daughter's in the front seat, oldest daughter's in the back seat. Mom, upon waking up, kind of starts to put her seat up and then rolls down the window and says, what's the matter, officer? Is anything wrong? And he says, no, just, there's been break-ins in the morning in this parking lot. And so we've been keeping an eye on things. And she says, oh, thank you. Thinking this officer was being helpful. Don't leave stuff in your car because people have been breaking into cars. And the officer then said, yeah, can I see your ID? And she initially says yes and starts to reach down for her purse to get her ID. And as she is doing so, you can almost see it on her face, like this change. Wait, why are you asking me for my ID? You were just warning me about burglars and now you want my, and couldn't understand. And anyhow, the officer said, yeah, you need to show me your ID. And then that essentially led to the detention because she refused to give him her ID, which she had every right to do under the law. The oldest daughter at some point got out of the car because she was going to go into Starbucks to use the restroom. The officers told her she couldn't leave the car. And eventually, like I say, all three ended up getting put in handcuffs in the back of 3 different police cars, detained in the back of police cars for somewhere around, 60 minutes or so. And then eventually released. When a sergeant was called to the scene, they eventually were released. But that's kind of the context of the case. Purportedly detained because of this. They were suspects of regarding these prior burglaries that had happened in the parking lot, when in fact there was nothing about them that matched any of the prior descriptions. Most of the time there was either no description. If there was a description, it was always a male. If it wasn't one male, it was 2 males at most, usually young males. So there just wasn't anything that was similar about our clients. I think in one occasion, Joseph or Brian can correct me if I'm wrong. I think in one occasion, somebody actually did identify a young black male. But other than that, there wasn't any reason to think that these women were suspects in any way, shape, or form. So that was the case. Brian and Joseph did all the work on this case. They took this case in, they worked it up, they fought all kinds of battles with really difficult defense counsel, difficult, bordering on dishonest. They had a lot of motion work they had to do to get this case finally to the point where it was ready for trial. And then, of course, COVID hit, and then that created a whole nother delay in the case. So the incident happened in September of 2019. And we went to trial in 2023?
February 2023.
There you go, February 2023. So it was a long course, particularly in federal court. That's, things move along in federal court, but it took a while. And that was in part because of the COVID pandemic. So
this was, if I recall correctly, this is Judge Alsup who conducted the trial, correct?
That's right.
And when you talk about borderline dishonest, that's not just your opinion, if I recall correctly. There were some inferences in terms of some of the findings that Alsup made post-trial about the behavior of defense counsel. Is that a fair statement?
Pre and post-trial. And again, I think, Joseph or Brian should speak to this because they were there for a lot of things that I was not there for, including Alsup's dressing down of defense counsel pre-trial on a very specific issue where he lied.
In the summary judgment hearing, the defense lawyer kept saying things that Brian and I were like, what are you talking about? That's not what happened at all. Of course, things that were favorable to him if they were true. And so when it was our turn to talk, we were like, Judge, that the thing that the defense lawyer said, that never happened. We had to do that repeatedly, and we kept pointing. We were luckily over-prepared for this particular hearing and kept pointing to page and line of the depositions or the record. And the judge kind of called the defense lawyer out at the hearing, and then in the order made it explicit that one of the reasons he was denying the defense summary judgment motion was because of all the misrepresentations of the defense lawyer. So it wasn't just an insinuation. He called him out explicitly.
We were able to fact check him in real time. The hearing was by Zoom. So we were logged in, we were locked and loaded, and we were word searching and pulling up chapter, line, and verse of where it was the opposite of what opposing counsel was saying. And Judge Alsup does not suffer fools.
Can you unpack that a little bit more in terms of how you made that happen? Were you able to present the testimony on the screen for the judge? How did you do that in a way that was just so impactful?
We didn't pull it up. We weren't sharing screen with the court, but he would say, where is that in the evidence? And we would pull up the declaration and say it's on page, 17, lines 24 through 28. It's just the opposite of what counsel's just represented, Your Honor. And then he'd say, opposing counsel, what do you have to say about that? He'd say, I misremembered that. And he just tried to obfuscate and move on to something else. But in the order, there were 4 separate instances, and Judge Alsup said, where's the effect of, defense counsel misrepresented. Fortunately, plaintiff's counsel were prepared. And he literally listed 1, 2, 3, 4 of the instances that we'd pointed out that he was misrepresenting the record.
One thing that we didn't cover in the narrative, and by narrative, I mean the description of the case and then the verdict, people hear about lots of different types of civil rights cases, and oftentimes they are police shootings, they are police beatings. This was a detention. Was there any physical impact on your clients? I mean, aside from the obvious of being cuffed and thrown in the back of the car.
No, that was basically it. It was some bruising on the wrists from the handcuffs and the arms, but that was it. Nothing that lasted any more than a few days.
Minimal physical injury.
And I don't mean to minimize the psychological impact of being cuffed and put in the back of the car. And I think part of the reason people are talking about this verdict and noting its impact on law enforcement and civil rights cases going forward is because the jury understood the significance of this. And that's a lead into, does somebody want to share what the verdict was?
Brian, you remember numbers well. What was the verdict?
Well, the verdict, that's a round number. It was $2.75 million for each of the plaintiffs, 3 plaintiffs, total of $8,250,000.
And then moving forward, because it was a civil rights case and because of some of the elements associated with civil rights cases, you were entitled to attorney's fees too, correct?
That's what they told me.
And then because it went up on
and interest, I think, right? Didn't we get some interest as well? I think, yeah.
Because it went up on appeal, there was interest, and the ultimate judgment was something north of $11 million, correct?
We never got a formalized judgment. What happened was post-trial, Joseph took the lead on the post-trial motion, opposing their motion for new trial, and our concurrent motion for attorney's fees and prevailing party costs and what have you. So I think the round number was Alsup awarded us attorney's fees of roughly $1,750,000. So when it went up on appeal, it was basically $10 million with interest accruing going forward.
I bring this up not because it's always just about the money, but because the message that verdict sends to law enforcement in terms of what is acceptable behavior and what is not. That then goes to some of the work in terms of putting it on before the jury. And broad question, what do you think thematically connected with the jury that helped them understand the significance of this event?
Every case, when you get to the end and you look back and you say, how did we get to that end point? In this case, $11 million. And I think there's three things that drove this verdict. The first was we had amazing clients. I mean, they were incredible. In fact, Brian and Joseph told me about them and couldn't say enough good things. And then I went and met them when they asked me to join them in the case. And after we were done meeting them, I was like, you guys lied to me. They're actually better than what you said. I mean, they're just A+ people. So we knew that a jury would, or at least it felt like a jury would like them. So that was one piece of the secret sauce. Second piece was that we had a defense attorney who just had and 2 police officers, quite frankly, who had a very loose connection to the truth, and just kind of couldn't get out of their own way sometimes. And that really, I think that really benefited the case in terms of driving the harm that was done. And then the third piece, which quite frankly, I think was the most important piece, was Joseph and Brian. They fought every battle before we got into trial. So by the time we got to trial, it was pretty well packaged up and ready to go. And what you just heard about in terms of like the MSJ ruling, I mean, they knew every fact in the case. And there were a lot of facts to deal with. There were a lot of rabbit holes to run down. And there's just, as my grandfather used to say, there's no substitute for preparation. They were so prepared and knowledgeable about the case that when we were in trial, it felt to me like we were the much more facile group to be able to work with combating the defense bullshit, quite frankly. And our information came in a way that felt very unassailable. So I think kind of those three things were sort of the underpinnings that helped get this jury to the verdict that they ultimately got to. But then sort of floating out there was then this environment that we just come out of with George Floyd and others who had been so horribly injured or killed or wrongly imprisoned by police officers. And I think that for our jurors, this was a moment to sort of take a stand, and they understood the challenge that our clients were going through in bringing this case, because as we talked to the jurors about in closing, the easy thing for the Loggervales to do would be to just walk away, right? They got released, just get on with your life. Bringing a lawsuit is incredibly inconvenient, time consuming, dredges up all those bad feelings that you had when the event was occurring. And they didn't do that. They said, we believe in our justice system. We believe that there's a way to right these wrongs. We believe that we can be better as a society. And if people like us don't take a stand and give this to a jury of our peers to make a decision about, then this kind of thing continues on. And I think that then is what allowed the jury to get to, and I agree with you, Miles. I think we talk about numbers the wrong way sometimes. The numbers in and of themselves aren't as important as what they represent. And in this case, I think the numbers are incredibly important because they represent the breadth and the depth of the harm that the jurors felt that these kinds of incidents not only do to people like the Loggervales, but they undermine our sense of community. Whether you're white, black, Asian, Latino, it doesn't matter. If you know that these sorts of things are going on where police are treating folks differently because of the color of their skin, that's a detriment to everyone. And we need to recognize that in the way in which we compensate it.
I wonder to what extent, because there are learnings across the board here. Defense lawyers listen to the program too. And at the risk of giving them learnings for their cases, early in your answer, you talked about how I won't land your euphemism properly, but not being as facile with the truth is a close way of saying it. If the defense lawyers had been more able to communicate truth, do you think that the jury would have had the same response?
I'm a former deputy city attorney in San Francisco, and I defended police. And the defense, in our case, in his closing, called our clients liars. And it just made it worse. The stars aligned for this case. We had a great team. Our collective wisdom far exceeded the other defense counsel. We had a great judge, difficult, but his heart was in the right place. And we had a fantastic jury. It was literally a cross-section of the Bay Area, and they got it. But if I'm the defense lawyer, I get up in closing and say, we don't think these deputies did anything wrong. But ladies and gentlemen, you might disagree with me, and that's okay. You're here to interpret the facts. And if you disagree with me, I think you should award each of these women $150,000 a piece. That's a lot of money. And so that's how I would have started my closing. So that way you've set a floor to contrast with Craig's ceiling. And Craig has not given himself enough credit. The closing was what, was the coup de grace, so to speak. He nailed it. And he quoted Rosa Parks and Martin Luther King, "The arc of the moral universe is long, but it bends towards justice." And it was riveting. As I told him, rarely can you do that and it doesn't sound hokey. It didn't sound hokey. He nailed it. And Judge Alsup coincidentally had a young female black clerk. I didn't notice this because I was, focused on Craig. Apparently she started crying and had to leave the courtroom in the middle of the closing. So, as a, somewhat of an additional juror, she saw the whole trial. She got it. And Craig emotionally connected with her, and he clearly connected with the jury because their verdict, they were pissed. And they're like, this was wrong. And everything about this case was wrong from start to finish. And that, because they rejiggered the verdict to make sure that it added up to 2.75 per plaintiff, because there's different theories for the mom and the two daughters. And they worked it so that they were clearly sending a message, and they rejected Craig's suggestion in closing. Craig suggested either 2.5 million or 30,000 per minute, which was 90 minutes. So 2.7. And the jury said, no, Mr. Peters, you're wrong. It's 2.75. So they were listening, and they're like, they turned up the volume just slightly more than what Craig suggested.
I want to go back and to the beginning. One of the things that I observed is that most civil rights cases that you hear about, there's an element of significant violence involved, but permanent injuries, death. And there aren't a lot of people that I'm aware of that have been historically taking cases like this, detentions only. I suspect that the result that this had will change that. And how did you reach the point where you decided that this was one that you were willing to take the risk?
The honest and simple answer is I'm kind of small peanuts, Miles. I don't have access to the great cases, the shooting cases. There's some heavy hitter civil rights attorneys in the Bay Area who advertise and have a big name and a track record. I'll take a good liability case because you get the fees. That's the benefit of these fee shifting statutes, is I know that I'll get paid for all my time a reasonable hourly rate if it's a good liability case. And often these are not. Often they raise really tricky questions about qualified immunity, and the police are often kind of given the benefit of the doubt, and there's all that going on. And so I wouldn't normally take a case without significant physical injury unless I felt it was really good liability. And I think that was one thing I've always had about this case, is confidence that what the cops did here was wrong. I never understood why they would have detained these women. And when I looked at it up and down and every which way, the only conclusion I could ever reach is that it's because they're black. Nothing else made any sense to me. And that got me angry, and it got me fired up. And Brian and I discussed it from the very beginning. I just said, I can't see how there's even reasonable suspicion on this. And for people who don't know much about civil rights cases or Fourth Amendment, reasonable suspicion is a very low standard. And so if you're arguing whether the cops had reasonable suspicion, you're often going to lose those cases. You're much better off saying that this was an arrest and the cops didn't have probable cause, which is a higher burden for them. We didn't even argue that. We dropped that. That's how strongly we felt that there wasn't even reasonable suspicion. We were willing to hang our whole entire case on that because I just thought it was so blatant. That was enough to get us fired up. And I didn't think the verdict would be what it would be, but I was always confident that we would win the case, get them something reasonable, and hopefully get all of our fees paid in the end.
I was looking up one of the 4,000 emails in this case. Joseph and I have worked together over the years on about a dozen or 15 cases. And I've learned that if Joseph thinks it's a good case, I'm on board. And we're both solos. And to do civil rights cases, it enables us to pool our resources, share the risk. And I love working with Joseph. So we had a meeting set up with the clients for December 19th, 2019. That was the official in-person meeting. A week earlier, Joseph sent me an email, a short email, and I'm quoting from Joseph's email, quote, "Since there was never reasonable suspicion to suspect the Loggervale family of any crimes, I can't see how their detention, handcuffing, and the subsequent search was in any way justified." Close quote. That's exactly what the jury concluded. but Joseph got there 5 years earlier.
As we talk a little bit about the facts, going back to the amount of time that they were cuffed and put in the back of the squad cars, 60 minutes seems like a very long time to figure out that these people had nothing to do with what had been going on. What was happening during that time?
Well, so a lot. As you know, with body-worn cameras now, a lot is recorded video-wise and audio-wise. And from my background as a public defender, I learned very early on in that role that a lot you can learn as much from what is left out as from what is included. So how many police officers were there, you guys? I think seven, 8, 9,
7 or 8. Yeah.
7. Yeah. I mean, there was a lot of cops there for nothing. They put these women in the back of these cars. They get their IDs from their car, from the Loggervale car, and then run their IDs. This whole time waiting for, by the way, both the daughters are calling 911 saying, we're being detained by these police officers and we haven't done anything. Please send help. And finally, the police take their phones from them so that they can't try and get help any longer. But eventually it's a sergeant who shows up, who is the one that speaks with each of the women and releases them. And I think, police have a hard job, and that was, I should say, part of our pitch was, we're not here because we're anti-police, and the Loggervales aren't anti-police. In fact, to the contrary, they hadn't had bad experiences with the police. But if you allow police to fall below the standard that we expect, then that sullies the name for the good police officers out there who haven't, right? And we all need to be held accountable in our jobs, whatever job we're doing, but particularly when we're law enforcement. And these officers had dug themselves into a hole and couldn't figure out how to gracefully get themselves out of it. Of course, it was saying, I was wrong. I'm sorry. Is there anything we can do to make up for this and show them on their way? But they didn't do that until the sergeant came. And so one of the things we also, because there was so much body-worn camera, we had some good clips in there of the police officers, for instance, before the sergeant came. They all turned off their audio. So their video is on, but their audio is off. And one of the things we asked the jurors is like, what do you think they're talking about there? Right? Like, why did they turn their audio off? That's weird. They're apparently investigating crimes. Why wouldn't they want to be heard why wouldn't they want to record that? There's also kind of the nonverbal, that I think also sort of shed light that the officers knew that they had sort of stepped in it. There was one point where the male officer who had originally approached the car, he's walking back to the car and he sighs, right? I think he sighs. And it was like, oh, that's the sigh of somebody who's like, how do I get myself out of this? And then when the sergeant comes later, after he's talked to two of the women and he's going to talk to the third, you hear him mutter under his breath, God damn. And it's like, he also knows, like, these guys and gals did not do this correctly. So anyhow, so that's all. And the sergeant during this time when he's talking to them is he's like, I want you to understand why they did what they did. And I don't want you to go away from here, man. I don't want you to, think that all police officers are bad. We're doing the best we can. And he's doing a lot of explaining to try to, sort of temper their understandable anger. And they do kind of calm down, although, still upset about what they've gone through. So that's kind of what took so long, I guess. It took a long time for them to say we were wrong, which they never. And that's the other thing, going to your earlier question. I think Brian's right. I think this would have still been a substantial verdict, but I think it would not have been nearly as large as it was if the defense had simply got up and said, you know what? In retrospect, we were wrong. That's not what the cops were thinking at the time, but in retrospect, we were wrong. We're really sorry what they went through. That's not what we're about. And you should compensate them each, $100,000 or $150,000 or something. I think that would have had a dramatic effect on the case, but instead they went the other direction and tried to attack.
Was there any disciplinary process for any of the people involved in this?
They got promoted.
Joseph, why don't you jump in? Because we had one of our claims, a Monell claim, for those who are not civil rights practitioners, there's no vicarious liability of the public entity. You have to have direct liability. And one of the ways to get the county directly liable is if they ratified the actions of the officers or the deputies after the fact. And Joseph did terrific work up there. So take it away, Joseph.
In all of my cases, I will submit an internal affairs complaint on behalf of the clients, and that's a good way to force them to actually investigate if they haven't already. We expect that they're always going to be unsustained, not sustained, because that's just often how it is. They don't want to create something that will potentially make them liable when they think they're not. But what we found out was that they just did a really, really cursory investigation. I think that they basically just reviewed the officer's police report and maybe the body cam videos. So Craig was saying earlier, the prior suspects in these break-ins were young men. One of them was a young African-American man. One was a young Latino man driving cars that didn't resemble our client's car. And they didn't bother to track down those police reports for those other incidents when they were investigating this. If they had, they would have been like, why did you detain these women? The car doesn't match, the race doesn't match, the gender doesn't match. So the sheriff just looked at what the cops did and what the cops said, took them at their word, no investigation, didn't attempt to interview the plaintiffs. They almost always try to interview the clients. I mean, I will say no, you can't interview them, but at least they ask. And so it didn't look good that they didn't even bother to ask us for an interview. And the sheriff, in his own handwriting, wrote on the top of the report, no further action needed. Basically, we're good with what they did. And under Monell, you need the highest policymaker for the entity, and that's the sheriff. So we had who we needed. We didn't even depose him. And it turned out it was a close call. One of the appellate judges dissented on this, actually, but it turns out that that's all you need for ratification in our case. So I think that's actually been helpful to other plaintiffs' lawyers as well.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. It's not lost on me observationally that we have 4 white guys talking about a civil rights case. And I say that in the context of the question that I'm going to pose, which I don't know that any one of us can answer. How many other Loggervales do you think are happening out there that are just not being acted upon? People who feel like their rights won't be protected because of who they are and their interactions with law enforcement.
A ton. I mean, I just know that from my public defender days, right? Like, this happens all the time. And it's a combination of the immunities that police are provided, which makes them feel untouchable, coupled with how long it takes for litigation to happen and ultimately come to a conclusion. This being a case in point, 4 years, something like that. Coupled with what you mentioned earlier, Miles, which is so many civil rights lawyers, their practice is somebody was killed, somebody was severely beaten, or somebody was in prison for years. Those are their cases. And if you don't fall into one of those 3 buckets, they don't have the bandwidth to handle your case. No fault on them. It's just it's just the way the practice is developed. And so, all those things conspire against somebody being able to even get an attorney, even if they feel like they've got the internal fortitude to get into the arena to do the battle. I hope more people are taking these cases, but because as Joseph said, right? I mean, it is right. These are the kind of things that can actually change society. It doesn't happen right away, but it can happen slowly over time. And if more people take these cases, and with the availability of getting your legal fees paid, even if the result is not a huge one monetarily for your client, it's a good reminder to these agencies that this is something that should be taken seriously. It shouldn't just be given lip service. And that's reminding me now, one of the things we had in this case, Joseph's position that there wasn't, there was no reasonable suspicion, let alone probable cause, we had somebody who was a post trainer who came into the trial because there is a hypothetical that's used in post training, which all officers receive, including these officers that we were going against, where you're given a fact pattern about basically a guy who's dealing drugs. And the fact pattern is that you go by the area where this guy has been known to be dealing drugs. He matches the race. He matches the age roughly. He's in the same location. And he's looking around, I think furtively or something, and putting his hands in his pockets. And the question is, do you have reasonable suspicion? And the answer is no, you do not. That's a better fact pattern than what we had in our case. And so we brought that person in. I think Joseph or Brian, one of the two of them, found this guy. And so we were able to put him on the stand and walk through that hypo and then say, okay, now let's give you our hypo. Also, no reasonable suspicion. And he said, well, yeah, based on just those facts, yeah, there wouldn't be.
Just to clarify, we didn't find him. The county put him up as a person most knowledgeable on one of our deposition notice topics.
Even better. Sorry. Right.
Yeah.
But Joseph dug out the POST is short for Peace Officer Standards and Training. Every deputized or police officer in the state has to pass a POST certification, and that's in their training materials. And Joseph found that and had that ready to go. And opposing counsel tried to block it and object and coach and every which way. And by this time, Joseph had beaten up opposing counsel 4 or 5 times on discovery motions that Joseph won every one. And he finally let the guy answer the question, and he was locked in. And then we called him at trial, and he had to stick to what he had testified his deposition. And I believe they tried to keep him out of trial, you know, that it was not relevant, redundant, what have you. And that was a very powerful piece of evidence. But Miles, to add to your amplify your prior question, we've all heard the expression driving while black and the dangers of driving while black. When I would tell my non-legal friends, both of them, I said, this was the parking while black case. It's gone to even another level. They're just sitting in a parked car, and they're hassled. And the 3 of us had the good fortune of being nominated by the San Francisco Trial Lawyers Association for this case to be Trial Lawyer of the Year. And I brought in one of my former clerks, an African-American man who he's been a lawyer for 10 years now. And just in talking to him, he goes, I can't tell you how many times I've been pulled over and hassled, even since I become a lawyer. And, you know, he knows his rights, and he's still hassled. And I was kind of both shocked and disappointed to hear that. It's like, it's 2025, and it's still commonplace. And we can understand it, us 3 white guys who tried this case, we can understand it intellectually, but we don't get it viscerally because it's never happened to us.
Layering onto that, and this may be a question for Joseph, but any one of you, a lot of our listeners are true believers, meaning they're doing this because they understand that without lawyers like us to help right wrongs, things will not be balanced. With that in mind, when people are approached with cases that have fact patterns like this, what recommendations can you provide to them to help them be more open to taking on cases that might be tougher appearing from the outset, but then turn into something like what the 3 of you were able to turn this case into?
I would say, are we talking about people who have experience doing 1983 cases or not? Because I think that might make a difference. If you're talking about a personal injury lawyer who gets approached with a false detention type of case, you know, it's tough to get up to speed. There's a whole big body of law on this. There's a lot of pitfalls, you know, and I hate to be that guy who's like, you know, don't try something that you've never done before. Cause that, you know, when I was coming up, people were like, you should, you know, bring in one of us from the big firms to help you because you don't know what you're doing. So I don't want to say that. But there is a specialized area of knowledge in these cases. And I think it really is important to know what you need to know because you will miss something very important. So if that's the case, you know, call one of the people who do this. There's a lot of people who do a lot of these cases all over the state and elsewhere. I'll give I don't know if this is something you want to leave in or appropriate for the moment, but I'll give a little public service announcement. I'm taking a break from the practice. I haven't been doing any new cases for a while, but I'm still really committed to what we're doing. And I'm happy to help if anybody has a case that they're interested in, wants to analyze a case, maybe knows something about this area. You're always welcome to reach out to me. I'm happy to just talk about it and tell you what I know and tell you kind of what you need to know to move forward.
And Joseph, that actually was exactly what I was fishing for. Was I think that there are a lot of lawyers out there who would like to make a difference, but are unconsciously incompetent, meaning they don't understand these types of cases. They can, potential client has reached them. They can smell that something's off, but they're not quite sure what to do with it. And what I'm hearing from you is you'd be willing to spitball that and help somebody figure out if there's a right direction for that.
Absolutely. And most of the civil rights lawyers I know, especially the smaller firms like Brian and myself, we're always happy to co-counsel if it's a good fit for somebody we want to work with, if it's a good case. And co-counseling is great. You get to stay involved, you get to learn a lot, and you have that resource. So I'd say that's another avenue to go.
Let me pile on with the co-counseling endorsement. As a solo, I won't take one of these cases by myself because you'll get swamped. We collectively had thousands of hours in this case. And from the time of our initial client meeting in December of 2019 to the time that the settlement check cleared in late December 2024 was 5 years. And Craig is tired of hearing me say this, but this case took longer than it took the United States to enter and win World War II. So you have to have long staying power. And that's, if you're a solo or a small firm, co-counseling is great because Joseph and I did most of the briefing up to the point of trial. We divvy stuff up. Okay, you take ratification, I'll take unlawful, detention, and then we would, then you're a drafter, you're drafting your work, you're editing your colleagues' work, and collectively, we had excellent work product. And if you pick someone you like working with, it gets you out of your little monkish existence as a solo, where you're talking on the phone or you're collaborating, and it's frankly it's more fun.
Craig, I also wanted to ask a question about your background being a public defender and whether you felt that your exposure to police officer behavior in the past from that lens helped in terms of your ability to take on this case, or to any extent, whether it might hinder in terms of you having an experience that, say, a common juror might not, from seeing things that some people might consider inappropriate.
I think it helped more than hurt. There is a personality type for police officers, plenty that fall outside of it, but 70, 80% kind of, there is a personality type that you get used to when you are, if you're a public defender, you're spending most of your time cross-examining police officers, whether it's in preliminary hearings or trials. So you get, you either get good at it or you get out. And in doing that and going through that process, you start to learn kind of what their defaults are. So I think that was helpful coming in. I had a pretty good guess of how the police officers would behave in this case. And they did. They acted true to form. They stuck to their story, which was not believable. Even after they knew facts that were different, they'd still repeat wrong facts. In terms of the experience, I mean, look, I'm a white guy. I have a different experience than certainly than the Loggervales have had in my life. But for that matter, I also had a very different experience from the majority of the clients that I represented as a public defender for, a decade and a half. But at some point, it starts to rub off on you a little bit. You're not experiencing it directly, but there's this, I don't know how to describe it exactly. It's almost like an emotional pall that just kind of sits on you. Part of it is, I'm sure, the job, but part of it too is just knowing kind of the uphill battle that so many of your clients have just in existing and kind of getting through day to day, the system starts to feel even more stacked than people who aren't public defenders might think the system is, right? And so that starts to wear on you. I think that may have been problematic for me had this case not happened after all America had gone through in the very recent past with so many high profile, egregious police officer cases where they were acting badly and people were dying or getting incredibly, horribly injured. So I think that was helpful. That was just a circumstance of the times that I think was helpful in this particular case. But I do echo what Brian and Joseph were saying about these. A 1983 case it's very different, and there are tons of pitfalls. And I'm doing some now, but again, like Brian, like Joseph has mentioned, I do them with somebody else because they're so difficult. There are so many pitfalls. And I need folks Joseph and Brian are incredible at knowing where those pitfalls are, knowing how to come up with a discovery plan that will, hopefully avoid those issues. And in this case, I think that was 90% of the case was dealing with that part. I got the good fortune of coming in and being able to sort of not have to worry about that piece because they had that. And so I spent my time thinking about what is the contrast here. And Miles, I know you try a lot of cases and you have a lot of folks on who try cases. And I think that's something to think about if you're going to do these civil rights cases and you're going to do ones that are like the Loggervales where the harm is this emotional, psychic harm that's going to stay with these people for the rest of their life. You have to figure out how do you create the contrast. Some good trial lawyers have said, everything is compared to what. And so coming up what the comparison is that will allow the jury to fully value the case, that is, I think, the hard part for a lot of people and why maybe they don't take these cases because they're not sure how do you create the contrast so that a jury will fully value it. And I had the time and luxury of being able to do that because Joseph and Brian were doing all the hard work.
In a related vein, while the case was worked up, I also seem to recall that you had a curveball just before closing, that the judge decided that there was a standard that you were going to have to meet that you had to modify your closing for with very limited time beforehand. Am I remembering that accurately?
So the verdict form required us to show that qualified immunity did not apply, which we believed was not appropriate. There is a split, although it seems like more anyhow. Again, now that's a Joseph and Brian issue. But that was part of our burden was to show that qualified immunity didn't apply. And it gets more complicated than that because then to do that, we needed to show that the police understood that in this circumstance, detention wasn't appropriate or something like that, right? But you would do that based on case law. But of course, how would the jury know what the case law is? Yeah, it was very...
Miles, what you're remembering is that after the jury had been charged and was deliberating, Judge Alsup switched the verdict form and gave it, amplified, modified. I wasn't there for that, but I think that was the issue. I'll let Craig or Joseph.
I think it was regarding putting the county on the verdict form and the qualified immunity issue. So the Monell claim, I think Judge Alsup thought for some reason that it only applied to the male officer, the male defendant. But we never limited it like that. And so I think we were just maybe, with all the stuff going on in trial, we didn't catch that the verdict form didn't include that the county could be liable for ratifying the act of the female officer whose liability may have even been more clear. She's the one who conducted the searches without a warrant. And that was a really clear part of the case. So we wanted that in there. And the judge said, you waived it. You didn't tell me that it was wrong in time. But Craig did a good job of convincing him that it just wouldn't be fair and that we never actually said that we wanted the verdict form that way. So it wasn't like we asked for the incorrect form. And so he said, the best thing I can do right now is actually just swap the form, call the jury in, give the jury the new form. There was nothing else to argue. He just told the jury what it meant. And they reached the same conclusion they probably would have, which is the county ratified the acts by all the officers. There was an issue with the qualified immunity. What Craig was alluding to is with qualified immunity. For people who don't know, it's a two-step inquiry. The first step is, was there a constitutional violation? And if there was, would all reasonable officers have known that what they were doing violated the Constitution? In other words, was it clearly established, which is typically a legal question for the judge. And there were some cases that went the other direction, but the current state of the law in the Ninth Circuit is whether the law is clearly established is always a question of law for the judge, not for the jury. And Judge Alsup had given that question to the jury, which was just, we had argued very strenuously that was wrong. And so part of Craig's job now, on top of arguing that they violated the law, was also that they knew they were violating the law and that the law was clear that they were violating. So it didn't make a lot of sense.
Part of the reason for my question was I recall going down to watch closing and Craig coming out and saying, I now have to do this new thing. And it was a curveball just before you were supposed to close.
We assumed the judge was going to get it right. And then he put qualified immunity on the verdict form. So it did come as a surprise to us. But
as you've pointed out, given the thematic approach that you took with the case and the facts and the bad behavior of the deputies and opposing counsel, the jury was going to do what it was going to do, it seems like.
Juries are a funny thing, right? All we get is their result. Even when we talk to them, that sometimes is, we're not getting the full skinny on how they got to where they got. So it's hard to know. But considering the findings, it does seem like they were on board that there was a significant wrong here that needed to be righted, and it was their job to do it. And they were going to figure out how to get that done.
I recognize the way I asked that question, it could be interpreted as that your closing was not impactful. What I meant by thematic approach to the case was that the work that Joseph and Brian had done to invest that theme through the case, and for you three to deliver it and you, Craig, to deliver it through closing. So, fair?
Yeah, Brian is very nice in talking about my closing. I'm a big believer that the jurors really kind of are hard baked into their opinions before you ever get to closing. Closing is just a way to, help carry the ball across the line for those good jurors who want to do that and convince the jurors that maybe aren't leaning that way that they should join them. Again, we never, you get a good result and you had a good closing. It's easy to connect the two, but I'm not sure that follows. And quite frankly, I think the reverse is true as well. I think, you end up giving a closing that's less than what you had hoped for and you get a bad result. I think we give a little too much credence to the effect of closing. In the grand scheme of things, I think opening is a far more important part of the case than the closing is. But that isn't to say closing isn't important. It just, I think its effect is kind of on the margins, whereas opening can really help create that framework that you're asking the jury to see the case through. And so from that standpoint, it tends to have more impact, I think.
On the appellate side, did you bring in anyone else to do the appellate work, or is that something that the three of you handled yourselves in some fashion?
We brought in an expert on 1983, our co-counsel, Joseph May, who I think he memorized the 1,500-page trial transcript. Joseph took the lead. I handled a couple of discrete areas on the appeal, but Joseph carried the ball across the finish line and argued the case in front of the Ninth Circuit panel here in San Francisco. But we kicked it around. Should we bring in an appellate specialist? And Craig deferred to Joseph and me on that. And Joseph and I decided, hey, no one knows the case better than us collectively. And we've briefed most of these issues. It's just enhancing or amplifying or addressing certain narrow issues. But there's nothing new that came up on the appellate issues. So we handle that in-house with Joseph being the main driver.
And I'm sorry if they're listening, but when we read the appellant's brief, we also just weren't all that impressed or worried. So that helped too.
In the Department of Chutzpah, my understanding is that once the verdict was affirmed on appeal, that the county still decided it was time to negotiate to try and shave some hundreds of thousands off what was owed. Can you illuminate that and how you continued to just have to deal with bureaucratic crap, for lack of a better description, and continue to push for your client's rights?
There was a little wrinkle in that the Ninth Circuit actually remanded one issue. So, it wasn't as though the Ninth Circuit said, we affirm as to all the issues, the judgment solidified. They had something to continue doing. But I think that almost worked against them because it was an issue that we think either didn't matter or that we were clearly going to win. And so we would just accrue more fees that they would have to pay. So I think that's when they finally understood. But yeah, they asked for a small discount. And it's at one point, I won't name names, but one of us considered entertaining it, but was outvoted, and they paid exactly what they owed us.
Joseph's leaving out the flavor here. He had the good fortune of fielding the call from a lawyer kind of at a higher level his job was to resolve the case. And Joseph relayed this to me, that the attorney called Joseph and said, okay, we've lost on appeal and, we need to resolve this case. And Joseph can correct me, but apparently Joseph just didn't respond. And the attorney said, this is where you tell me how much it's going to take to resolve the case. And so Joseph said, all right, well, let me get back to you. And what we did is we tallied up all the hours that we had incurred since Judge Alsup's ruling. So all of our appellate hours and interest, and it was an Excel spreadsheet by the time we were done. And since the attorney was representing the county, this call came in late September. Said, give me a number that's good through December 31st because I've got to get it through the board and various levels of excess and what have you. So we went back and Judge Alsup awarded us an hourly rate in 2023. He had Craig at $950 and me at $850 and Joseph at $700. So we're now in late 2024. So I suggested that we give each of ourselves a 10% raise. And then we took those new rates, multiplied it by the hours, and we did diligent record keeping of all the time we spent. And we presented them with this number, $11,266,000 and change. And the other attorney responded and said by email, how about 11 million flat, and we'll call it a day. And Joseph and I were indignant. I forget who the third person was who said just compromise, but Joseph and I were indignant. We had a written settlement offer, so we had to communicate it to the client. So I took the lead, calling the clients, and I said, the defense wants to steal $250,000 from you. If you're okay with that, we'll accept this number. But if you're not, then we're prepared to keep fighting. And they were righteously indignant, as I expected. And we had the leverage. And on the plaintiff side, we rarely have the leverage. But our position was, okay, fight it, county. We're gonna have another fee petition in front of Judge Alsup, and he's going to give us something close to what we're asking. And the beauty of these civil rights cases is once you've won, there's a concept called fees on fees. We would get fees for bringing the motion and writing the reply brief and showing up at the hearing. So it would just have kept going. And the higher level attorney for the county realized that. He was just trying to see if he could bottom fish a little bit. And Joseph had I've saved this email as well. The plaintiffs reject your $11 million offer. And the number is, blah, 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 and 62 cents was the final. And to his credit, the attorney responded 2 hours later, deal. And he had the authority all along, but he was just fishing. But that was, and on the plaintiff side, we're never, completely in the driver's seat. There's always some risk. There's always some ability. Something could go wrong. But Joseph and I are like, we've been in this slog far too long. We're not taking our feet off their necks at this late juncture. So they paid that to the penny.
And that's all in contrast to them just before trial offered something just shy of $1 million, right? I think.
There was a primary $1 million policy, and it's called a wasting policy, which means as defense costs are incurred, that reduces the $1 million. So by the time we got to trial, the same attorney who ultimately settled the case for the county said, I hear you. Joseph and I were on a call with him and just said, this is all I can do. I can't get any more authority. Here's $760,000 or something like that. And Joseph and I politely told him that ship has sailed.
Because at that point, arguably, it wouldn't have even covered attorney's fees, probably. So,
yeah, we were over $1 million in fees at that point before trial.
But that's also in contrast to people saying they thought the case was worth, my informal focus group of a bunch of trial lawyers was like $250,000 total for all three. So, good for Joseph and Brian saying, yeah, we're gonna forge ahead.
Thank you for listening, and please join us next week as we continue this conversation. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have for who you'd like to see on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.